Keeping your business healthy in today's marketplace can be a challenging and overwhelming task. From the threat of litigation inside and outside your organization and the inefficiencies that can rob your bottom line as a result of unproven marketing programs, the deck can be stacked against you. To get ahead of these challenges and stay ahead of your competition, the Bottled Business Sense Show provides practical business solutions that uniquely emphasize key legal principles, management techniques, and marketing strategies to protect and ensure the longevity of your business. You'll learn how to implement marketing and protection principles equal to those used by today's most successful corporations. Join your hosts Bill Bernard, Rick Moscoso, and Steve Smith for some high-energy discussion that will inspire you to take control of your business so it can prosper in today's consistently challenging business environment.
Good morning, everyone. I'm Rick Moscoso here on the Bottled Business Sense Show. Today is Tuesday at 10 a.m. and excited to be here today with my co-host, Mr. Bill Bernard. He's on the other side, but before we get to Bill, I just wanted to welcome our viewers and listeners out there. Welcome back to the show. Love to have love having you here and learning about some of the topics that we've been talking about over the last year. A little over a year now.
Gotta be
and
closing. Yeah, summertime. Rick will be closing in on 2 years. Yeah.
Yeah, closing up on 2 years. But, Bill and I started this show almost 2 years ago and wanted to provide all of our listeners and viewers really with free information in regards to legal and marketing topics that we've been talking about now for quite some time. So that's really our offering to you out there, for those of you interested in watching and listening to the show. Hopefully you find it of huge value and keep coming back. We have a huge archive of previous shows on our website at bottlebusinessshow.com. You can also go to blogtalkradio.com/bottlebusinessshow and listen to our audio archive there as well. You can also find us on social media as well as Google+. And would love to have your feedback or input, or even if you'd like to be a guest on the Bottle Business Sense Show, we'd welcome that as well. And you can always send in inquiries to bottlebusinesssenseshow@gmail.com. So with that, let's get right into it this morning and bring on my other co-host here, Mr. Bill Bernard. How are you doing today, Bill?
Rick, I'm doing fine, thanks. Just soaking up the last of the weather here in the South Pacific, before I head back in mid-February, and trying to get my work done in between a little bit of leisure time. Not too much time for leisure activities, but I try to work it in when I can. And I'm glad to be here as well today. I'm always happy to help our viewers and listeners, our entrepreneurs, our business people, in terms of helping them learn about legal issues that they need to be aware of in growing their business and making sure it's protected. And of course, from a marketing standpoint, we try to allow them to prosper by our tips as well. And you did a great job opening up, letting everybody know where they could get a hold of us. Today, I thought we would talk about the basics of buying and selling a business, because I think a lot of people out there are buying and selling businesses, whether they're startups or whether they're mergers or some sort of acquisition of an established business. There are certain things that they need to be aware of. So what I thought I'd do is break down the show into basically four categories. One, I want to just talk about what the sellers are interested in when they buy a business. When they sell a business, what the buyers are interested in when they buy the business, what legal issues you generally want to be aware of, and then more specifically, the fourth area would be the purchase agreement itself and what you want to make sure is in that purchase agreement. So we have a little bit of foundational stuff today, along with some more specific stuff in terms of what they're going to need to move forward.
All right, that's awesome. I know I've seen businesses being bought and sold. In fact, I network quite frequently with a gentleman who buys and sells business for others, and so I know that the information here is more slanted towards the legal side of it. But Bill, why don't you start off here with the seller side and let us know what we should be what we should be aware of if you happen to be a seller for a business.
Yeah, and while some of this may seem like it's common sense, again, you'd be surprised at what little a buyer may know about a seller or what a seller may know about a buyer, especially if you're buying into a business for the first time. So what we really generally have to keep in mind, Rick, is sellers are interested in the price, of course, but more importantly, whether that price is going to be deferred in some way or whether they're just going to pay it up front. They want to know the terms of the transaction, what the price is going to be, and they also want to know if a buyer is later going to make a claim that because the business fails to meet the buyer's expectations, is the seller going to be a target? Does the seller have a target on his or her back once the purchase is culminated? So the price is always important, but also the terms of the agreement are going to have to be such that the buyer's expectations are met, not so much in the sense that he or she has a crystal ball and knows what's going to happen, but that the proper terms are inserted in the sales agreement so that a buyer knows that he's basically getting the business as is. And I use that phrase, as is, loosely, because it could be as is in terms of take your best shot, or it could be as is in terms of here's what the business encompasses, and that's what you're getting, period, end of story. And that the second way, of course, is always the best way in my view. The buyer's also, the seller's also going to want to be aware, is he or she going to have any continuing liability to the former customers of the seller. In other words, the seller wants to make sure that continuing liability to former customers is not going to be a seller's concern. Once he or she sells the business to the buyer, that's going to be it. The buyer is going to assume all future liability, if any, should any crop up. And there could be subleasing issues. The seller may have subleased the property to somebody, and now the buyer is buying the building and the business, but he or she, as the buyer, must be concerned about a sublease. So the seller is going to want to make sure that he or she is extricated from that sublease, and that he or she doesn't have to worry about any future concerns on the sublease. So there may be another agreement that needs to be mulled over. And finally, sellers are often required to respond to due diligence requests by buyers. What that means is if you're buying a medical facility, for example, you want to open up a medical practice, that seller is going to want to make sure that he or she informs the buyer what the zoning is for that building. Because let's say somebody moves in and wants to open up a medical practice and it's not zoned for medical. And more importantly, the association, who is oftentimes involved in the management of these buildings that are owned, much like neighborhoods are, may have restrictions on parking. And those restrictions on parking may also prohibit a certain type of practice being opened up in that building. So here's what I would say. In addition to price, in addition to meeting expectations of the buyer, in addition to making sure there's no liability that's continuing from former customers or clients, there's going to be a due diligence factor. Those are the main concerns of the seller. How much is the seller going to be required to do due diligence and inform the buyer of certain concerns the buyer might have? That's going to be an interesting topic.
So this is...
Go ahead.
Yeah, this is not, it sounds very similar to, a little bit more complex, but very similar to buying or selling a house, for example.
Well, in many ways it is, yeah. Although when you deal with commercial leases and commercial properties, you really have to be concerned more about zoning issues than you do, obviously. Those are not concerns when you buy a personal property most often. Unless you intend to open up a business on that property later on, in addition to where you reside. Conversely, the buyer is going to want to avoid any seller liability from prior vendors, right? He wants to buy the business, he or she, and doesn't want to be burdened with any liability claims that might be sticking to the seller by way of any vendors or clients that the seller previously did business with. He wants to make sure, the buyer that is, that the seller is not going to compete against him after the business is sold, right? And open up the same sort of business and compete against him or her. The buyer is going to want to make sure that the commercial lease that he or she may enter into is enough of a duration to where the buyer can establish the business that he or she wants to establish. We want to make sure that the lease isn't going to expire before the buyer's opportunities are met, right? So that's a concern by the buyer. In addition to that, here's a big one. The buyer is going to want to know if key employees intend to stay with the business. Because if key employees decide to leave, they could take valuable customers with them. And remember, in California, if you are an owner of a business, you can enforce non-compete agreements. But if you're an employee of a business who leaves, that employee can go ahead and compete against the new owner of the business because that employee was not an equitable owner in the business to begin with. So what does that mean in the short term? It means that non-compete agreements in California are not enforced against employees or independent contractors. They're only enforced against owners. So an owner sells you a piece of property. You're now the new owner. You want to make sure the old owner doesn't compete against you. But the old owner's employee, Joe Blow, could go out and compete against you all he or she wants. So you're going to want to find out ahead of time how many of these key employees intend to stay and whether or not any of these key employees are going to compete against you once the business is sold to you. You can't always foresee that, 100%, but certainly you want to do your due diligence and make sure you investigate that. And then finally, buyers have an interest in seeking financing help, right? They want to make sure that they have the ability to buy the business and to purchase it at the price that's been negotiated. So there is back and forth on this thing. And now going back very briefly to the due diligence that the buyer many times asks the seller to verify. It's not surprising to me at all that in most instances, the buyer is going to be responsible for doing her or his own due diligence. So if that building that the buyer buys is not zoned for medical, you may go after the realtor who listed the building. You may even try to go after the seller. But you're going to have some liability if you didn't do your own due diligence yourself or through your own broker to ensure that that property was properly zoned prior to your purchase. So
there's a lot of considerations here on both sides when you're looking at doing something like this. Let me ask you something. So when a buyer's looking at purchasing a business from someone, and I assume that the seller is going to be obligated then to open up their books, so to speak, to disclose any of these prior vendor commitments, tax liabilities, and that sort of thing. What type of disclosure, or is there a disclosure agreement, or is this confidential information that he can't take on? Should he decide not to buy it and go someplace else and look at something else? Are they bound by any confidentiality?
Typically not unless it's a trade secret of some sort. But even then, you wouldn't be bound because the new buyer is going to want to know what trade secrets he or she is going to be purchasing along with the business, right? So typically no, but all of that would be negotiated and either inserted in the purchase agreement, or the purchase agreement would not be even addressed until all of those things were provided to the buyer and the buyer is satisfied. Here's a key aspect of the question you asked. Before you sign a purchase agreement for a business, make sure prior to the agreement you've done all your due diligence, not only in terms of the zoning issue I mentioned, but in terms of the books, the liabilities, all of the things that come with the business. What assets does the business own specifically? What liabilities do they have, whether from a tax standpoint or from a civil standpoint? Are there any vendors or clients out there that may have potential claims? Is there any money owed to the business? All of the books, yes, would be opened. All of that would be looked at, and all of that should be done both with respect to a lawyer who's on your team and a tax accountant or CPA, so that these issues are covered before you enter the agreement itself. Okay? Now, you may reference certain paragraphs in the agreement saying this was done, that was done, but the real crux of the agreement is the actual purchase and sale. So you presume at the time you're ready to make the purchase and the sale that all of the preliminary things have been investigated and you have been the business has been properly vetted. So yes, the books would be opened, the assets would be exposed. You could have an accountant come in and review the books. You could have an attorney look over the documentation within the company in terms of the entity structure, if that's necessary, what the entity has purchased and sold in the past, what the entity's obligations are to any other people that may be involved in the business. All of that needs to be looked at. And that would fit into these categories that we discussed when we talked about the fact that the buyer wants to make sure that the business is going to fulfill his or her expectations. That includes looking at all the books, whether there's any continuing liability to former customers or clients. We've talked about that. What the lease situation is, all of these things we covered would involve that due diligence that you're speaking of.
So what additional things, let's say I'm interested in buying a franchise. So is it, same things apply? Is it easier, the process? Talk a little bit about that.
Excellent question. In fact, it would be very similar, except when you're buying a franchise, you're going to more than likely be required to have approval by the franchisor, right? So you're not only going to have to sign a purchase and sale agreement, this time not for the entirety of the business, but for the business assets, because that's what you're buying in a franchise situation, not the actual stone wall, the brick and mortar. So you may then have to go ahead and sign a separate agreement with the franchisor as to what your restrictions are and what you're expected as the franchisee of that franchise. So in effect, you're going to have to be approved by the franchisor. So what do? You make sure that you're going to be approved by him or her prior to entering into negotiations to buy the property with the seller, right?
Mm, right.
So that's a very important issue, and it's a question I'm glad you brought up. I want to talk a little bit now beyond the expectations of the buyer and seller, what the related legal needs might be. Remember, I said legal needs, not legal requirements. Do you want to now form an entity? Perhaps the business you're buying didn't have an entity attached to it to begin with, so now you want to form an entity. Do you want to enter into or extend the commercial lease that's on the property? Do you want to enter into a commercial lease that's longer than the one you currently have? What's the status of employees and independent contractors? Who's the employee? Who's the independent contractor? You want to be able to distinguish those. You want to talk with an attorney so you know what the distinctions are between an employee and an independent contractor, so you therefore know how to deal with them separately. And you're going to want to know what contracts and agreements are available for you, right? What contracts are you going to have drawn up that are particularized to your business that now you can deal with your clients and your customers, which may be far different or somewhat different than the business customers and clients the seller had when he or she owned the business, right? And then, of course, finally, trademarks and other potential intellectual property rights. You're going to want to know, you're going to want to determine whether or not there's anything you want to trademark, whether or not there's anything you want to copyright in the business. So summarizing legal needs real quickly, do you want to form an entity? Do you want to extend the commercial lease? Make sure you're aware of who the employees are, who the independent contractors are, and how you deal with them individually. Number 4, do you need contracts and agreements drawn up that are particularized to your business? And number 5, any intellectual property issues that may be out there, with more specifically, usually involving trademark situations.
Okay. So at the top of the list here, you have forming an entity. What if the business already has a encompassing entity? Does that get dissolved and then you create a new entity for that business? How does that work?
You could do that, certainly, if your business is going to be, if you want the name of, if you want your own name, you would. If you want the business name It could be sold to you in conjunction with the sale of the property, and then there's ways that you go into the Secretary of State website, or you go to an attorney, and specific documents will be filed listing the new owners of the company and what their positions are, whether it's an S Corp, an LLC, that sort of thing. So typically it depends on what you're buying. Obviously, if you're buying a business and you want to carry with it the name, that name is going to be included in the purchase price. If you're buying a business and you want to switch it over into a totally different new business, then the seller will dissolve the prior business, and then you will go ahead and speak to a lawyer about forming your new entity in terms of what entity is right for you. That leads into some side issues, actually. Do you need to sit down with a lawyer and determine what entity might be right for your business? Is it an S Corp? Is it a LLC? Is it a limited partnership? You're going to want to determine how that fits in. So in addition, again, to the buyers and sellers awareness items, I guess you'd call them, the things that they each need to be aware of, the things that they're each concerned about. In addition to those, you have legal needs that you need to sit down and discuss with a lawyer. So this goes in a perfect kind of like a domino effect. You review everything, do your due diligence, you make sure that the buyer and seller's needs are met. You then sit down and talk with a lawyer and CPA. You make sure the books are reviewed, you're satisfied with everything that you're looking at within the business. You then sit down and make sure that you understand all of the legal needs that might crop up. Once you understand that, once you think it's something you're feeling good about, once it's something that you feel confident would be good for you, then you enter into a purchase and sale agreement. And that brings us to the last subtopic for our show today, and that is, what should you look for? What should you practically have within that agreement to make sure that all the I's are dotted and all the T's are crossed? Okay? Because remember, the first part of this has been, is the business right for you? Now you're coming to the contractual part to make sure that the terms of the sale itself are complied with and set forth to your satisfaction. So the first thing we would look at, obviously, and I'll run through these rather quickly because they're pretty basic. The purchase price and the method of payment. How is the business going to be paid for? Is it going to be financed? Is it going to be paid for all at once? The terms and conditions of sale, right? What are the terms and conditions of sale? If you want to go into depth in terms of the due diligence and insert those things that we talked about earlier in the contract, you can. And you can address the more important ones so that you're agreed as to what the limitations and bounds are for the sales transaction. Okay? That you're going to be taking over this building, that the lease is for such and such a period of time, right? That the buyer is going to comply with certain issues within the agreement, that the seller is going to comply with certain issues in the agreement. Part of those would be warranties. The seller is going to warranty certain things in the business, right? That this business is in debt to X amount of dollars, or this business is not in debt in any way, shape, or form. Now you've reviewed the books, you know that to be true. You might want to reduce it to writing and make sure it's inserted within the agreement. All of the promises that the seller has made to you to make sure this deal can be entered into can be represented as warranties within the agreement. Next would be actions the seller has agreed to take prior to the sale, such as paying off existing loans, securing the resignation of employees who may not want to stay on board. All of these things, again, that you discussed previously, you were asking me if it could be inserted in the contract. These are issues that could be of concern, that are of such importance that you want to make sure they're inserted in the contract itself. Details of the business to be purchased. What are all the assets? Okay. What are the liabilities? Those things should be listed within the agreement. And also a list of all the creditors who are to be paid off. Creditor A, B, C, D, E, F, G will be paid off. This is how they will be paid off. This is when they will be paid off. This is how much that are owed to each creditor. That should be inserted in the agreement. And how much of the commission is going to be paid to each of the brokers who brought this buyer and seller together. That should be included in the agreement. And also, we need to make sure that in the agreement, any disputes are resolved in a manner that's conducive to the well-being of the buyer and seller, meaning that you may want to avoid court intervention should you have a dispute over something in the business at a later date. You want to resolve by way of mediation and or arbitration as opposed to going to court. You want to make sure.
Are you talking about a dispute between the buyer and the seller?
Yes. And that in other words, if there's a dispute over the terms of the contract or any of the representations made, you want to make sure that that dispute is resolved most often by way of mediation and arbitration as opposed to going to court. It doesn't mean that it's always going to be less expensive to do that, but many people feel that it is, and many people feel that without involving the court system, you're going to get a quicker resolution because you're going out and hiring a private party to adjudicate the issues.
So what would happen in the instance everything looks good, both parties are in agreement for the transaction to go through, the sale's done, the purchase is done, and then out of the blue, you have an outsider who comes in and decides, I because of whatever happened a year or two ago, I'm going to sue the company. Who's on the hook for that?
Well, that's an interesting aspect. If the claim is against the company, and if the company has been bought by the new owner could be responsible for fighting it on behalf of the company, not personally, but on behalf of his company, and then look for payback from the old seller, right? Because that seller was the one who presumably caused this lawsuit to occur. So if a claimant comes in and sues that company, then the new owner is going to want to have an attorney who can defend that new owner and also make a counterclaim against the old owner of the business in order to resolve any issues that might be outstanding. Remember that if it's a sexual harassment claim or some sort of a dispute involving a civil rights claim, and if the old owner either participated in that personally or was aware of it and didn't do anything about it, then that old owner, the seller, could be personally liable in addition to having the company held liable. And of course, the company, as it currently stands under the ownership of the new buyer, is going to want to make that counterclaim against the old company and say, basically, really, your claim is against this guy. He's the one that caused it, not me. But again, you're going to want to make sure that there's no claims existing against this company when you purchase it, right? That's part of your due diligence. And as far as someone coming out of the woodwork, all the personnel files of the people, past and present, should be reviewed, okay? And that's where you need a competent employment lawyer to do that. And you should make sure that you're aware of the statute of limitations. If there's any potential claim that could happen down the road that might raise a red flag upon your review of the files, you're going to want to know when that statute of limitations runs on that particular claim, should it come down the pike later on. Another way to do it, Rick, is to negotiate. In the contract, we don't expect this to be a claim, but you assume all future liabilities, Mr. Buyer. The buyer may agree to that. If he does, then he's going to have to just deal with it at the time that it comes down the pike. However, I would submit to you that even under those circumstances, it wouldn't be surprising to me to see an attorney assert a claim against the old seller, or at least try to get some money back from the old seller for what he or she did previously, if that can be proven.
Yeah, right.
If it's just a claim against the company itself and you're going to have to defend it, the agreement might say you're going to assume all claims and future liabilities. The agreement might say that the seller will acknowledge that any future claims that come down the road within the next 5 years or 3 years or wherever is negotiated will be assumed by the seller should the new buyer be sued. So there's a number of different ways to handle that, Rick.
Yeah. It sounds
You're
like
also going to want
to... Go ahead.
Go ahead. Yeah. Now I was going to say, you also want to make sure you have a provision for attorney's fees in this agreement, the buy and sell agreement. You want to make sure that you cover the issue of non-compete. You want to make sure that there's a non-compete provision in there. A lot of times people want a separate agreement for a non-compete. I would submit to you in a well drawn up a sales and purchase agreement, you could insert that in there as a relevant paragraph and have it initialed by the seller that he or she will not compete within 5 years, within 5 miles, or whatever is deemed to be reasonable by the parties, and have the seller initial that, and then of course sign the agreement at the end. You want to try
for what reason would they want that in a separate agreement?
Well, because a lot of times people want to call attention to it, and you can call attention to it by having a separate agreement and saying that not only was this wasn't just hidden in the original purchase and sale agreement. This is a separate agreement that was acknowledged, read, checked out by the seller's lawyer, and the seller agreed to it and signed it. And then that could actually be an exhibit. We haven't talked about exhibits, but you can make relevant documents such as a deed to the property, such as a non-compete provision. You can make those exhibits to the purchase and sale agreement. So Exhibit B might be the non-compete agreement.
Yeah.
So these are all things that need to be thought of and reviewed and worked out. And remember to include, as I said, an attorney's fees provision, because should somebody have a dispute over the agreement, you're going to want to make sure that the winner of that dispute, the dispute over the purchase and sale agreement, is going to be able to recover his or her attorney's fees.
Right. So before we wrap up, I don't remember you talking about this, but briefly, what do you do in the case of trademarks or intellectual property?
Well, you would see if you feel competent enough to do it online at the U.S. government websites, you can do that. But I would see a lawyer. If you feel your business lawyer knows enough about it to be able to get through it, then hire him or her. If not, see an intellectual property lawyer who can file the proper documents to make sure your trademark is not under siege at some later point in time. Should that occur? And remember, you're going to want to do a literal trademark. You're not going to want to do, if you have a trademark, your mark, like whatever it might be, whatever your business name is, whatever your logo is, you're going to want to make sure that is done by way of a literal application, not by way of an application that has a picture of something with your trademark on it. Because if that's the case, many times people mess up and they'll file the trademark application and have on there a specimen that has their mark on it, and then they go ahead and fill in the fact that they want the whole thing trademarked. Well, you'll not only get the mark will be trademarked, but only for purposes of the specimen that it's on, not for all times, not for the mark itself. So you have to do a transaction that doesn't require the downloading of a specimen, but rather just the insertion of the name of the mark and get that done appropriately. So it can get tricky.
Yeah, it sounds like it could be tricky, and the mention of a specimen sounds a little clinical to me.
Well, that's what they call it. When you download something that you want to have, let's say you have a magazine and you want to trademark the magazine logo, but you download the logo that's on a magazine cover from July of 2015. You could end up having just that July 2015 page with the logo and the background page on it. You could just end up having that trademarked, and now you're in July 2016. So who cares?
Yeah. Who cares? We're running up on the end of the show, but we did talk about this in a previous episode when Bill talked about trademarks, and somehow Trump got thrown into that conversation, which we won't get into today. But with that, Bill, excellent episode. This is a lot of valuable information for our business buyers and sellers out there. And if you'd like to continue the conversation with Bill, what's the best way for them to get a hold of you?
Well, of course, WFBlegalconsulting.com has my phone numbers. The phone numbers are 949 area code. The business office is 698-6222. The cell phone is 413-6535. And, of course, you can get a hold of me at bill at wfblegalconsulting.com. And I'd be more than happy to speak to you about all of these issues. Again, recapping the seller's interest, what they're most interested in before they buy a business, what the buyers are most interested in before they buy a business, sellers most interested in before they sell, buyers most interested in before they buy, what the legal needs might be to start your own business once you purchase it, and of course, what needs to go into that purchase and sale agreement itself. That's very critical. I'm happy to talk to anybody about that if they want to, get a little more detailed in that regard.
All right. Well, that's great. Everyone out there, thank you again for joining us for this episode on the Bottle Business Sense Show. We, on behalf of Bill and myself, want to wish you a very happy and prosperous week. And we look forward to sharing with you again next week. So with that, have a great week, and we'll see you again soon.
Have a great week, everybody. Bye-bye.